it'll be quick so we can get on with the show. I'm Bud Bazelak, the Provost, I think as many of you know, and on behalf of President Barbara Snyder, who's also a faculty member in the School of Law, let me welcome you to Constitution Day 2014 Forum. This is an event that I first learned about, I think, just about the time I arrived here, maybe 5 or 6 years ago. I never realized there was actually a day that celebrated the Constitution, nor that it was a requirement of institutions who receive federal funding, which is, I think, another interesting aspect of this day. But it really is, you know, having visited and having listened to some outstanding presentations and dialogues between our students and outstanding guest lecturers, it's been a very interesting experience. I've learned a lot, and I actually very much look forward to this every year. We're fortunate this year to have Professor James Pfiffner from George Mason University on a great topic, again, as always every year, a very timely topic on executive overreach to president on his own. So with that said, I look forward to the engagement. I want to appreciate the students, the committee, the organization committee, the panel members, Dean Etten for his participation in this event, and just have a great dialogue, and I look forward to it. Thank you.
Thank you so much, Provost Bazelak. Good afternoon, distinguished guests, faculty, students, and friends. My name is Caroline Bass, and I am the Mistress of Ceremonies. The purpose of today's forum is to celebrate the 227th anniversary of our founding charter, the Constitution of the United States of America. It is an honor to welcome Professor James Pfiffner of George Mason University. The Constitution Day Student Committee appreciates your taking the time to discuss the historical, political, and constitutional evolution of presidential power and to answer our questions. From sweeping internal surveillance and aggressive drone strikes, the actions of the executive bear far-reaching domestic and international consequences. The issue of the extent of executive authority is a very old one. This forum will discuss executive power and overreach and explore the controversies surrounding its expansion and recent constitutional challenges. I would also like to introduce our discussant, Dean Jonathan Enton, and our panelists. From my right, Jacob Martin, Haley Rashashin, and Quinn Winters. Now please join me in welcoming Professor Pfiffner.
Thank you very much, Carolyn, for your introduction, and thank you all for coming here this afternoon to celebrate the Constitution and signing on the 17th of September. What I'd like to do is say several things, first about some of the origins of this Magna Carta, a little bit about the creation of the Constitution, and then some remarks about recent assertions of executive power in the United States that I think have been pushing the Constitution a bit far. So next year, 2015 is the 800th anniversary of Magna Carta, which was King John put his seal on the Magna Carta, didn't sign it back in 1215. And it was originally, this is sort of the core touchstone of individual rights in Anglo-American jurisprudence and throughout the world. But it really wasn't created to do that. It was created by the barons, the local barons in England, who wanted some independence from King John. And so all of the, there's maybe 100 different items in it, and they're about tax law and inheritance and so forth. But there's about 3 or 4 things that really stand out and that have lasted through the ages. One of them being that the king can't take your property or throw you in jail without some sort of due process of law and be a trial by jury. And if somebody's going to be imprisoned, they have to produce evidence. There's no selling of justice, that is corruption. And so we sort of take these things for granted. But the reason we take them for granted is because since Magna Carta, these elements of due process, individual rights, and also important limits on the executive, the sovereign, have come to characterize American Anglo jurisprudence. So the Bill of Rights that we have in our Constitution is a descendant of that. And the United States sovereign is, President, Congress, and the judiciary. But we have to limit those powers, and of course, the separation of powers does that. Recent years, some of these rights have been threatened. I'm just going to mention a few and then go back and talk about some of them specifically. But one is indefinite imprisonment of somebody without access to habeas corpus, suspending the laws of the United States and international laws against torture, suspension of the Fourth Amendment rights to privacy, signing statements, targeted killings, going to war without congressional approval. So all of those things I want to touch on. But first, a little bit about the creation of the Constitution itself. So the leaders of the Revolution in 1776 went to war against Great Britain, in part because they thought they were being deprived of their rights as Englishmen. They thought, well, we've got these individual rights, and Parliament and King George III are depriving us of them. And so the colonies' experience with the colonial governors, well, King George also, who was an executive, and the colonial governors who were oppressing them before the Revolution, gave this creators of the Constitution and the revolutionaries very much a suspicion of executive power. And of course, looking back throughout history, the major threats to liberty have come from executives because they have all the power. They control the military, they control the police, and so forth. And so they were reacting against that. So they set up the Articles of Confederation after the Revolution, and since they were so suspicious of executives, they did not create a separate independent executive. The Continental Congress ran things through committees, and if you've ever tried to run or manage something with a committee, you know that that's a very difficult proposition. And basically, it did not work very well. There were conflicts among the various newly formed states. They were putting up tariffs against goods coming in from other states. There was no coherent foreign policy. Great Britain was threatening to make peace with the separate states rather than with the United States itself. And there was no way of raising taxes. They could assess the states, but they couldn't force the states or individuals to pay taxes to run the central government. So there wasn't a very coherent government, and that's why the Framers met in 1787 in the summer to create a stronger union and a stronger central government. And they began, of course, with this suspicion of executive power. But after the Revolution and before the Constitutional Convention, the state legislatures, which had been created after the Revolution, they were all very suspicious of executive power. So they created strong legislatures, and they didn't give much power at all to their executives. The state constitution in Pennsylvania didn't even have a chief executive. And others had one-year terms, and legislatures had a lot more power. But what they found out was that this led to legislative abuses. Legislatures were acting arbitrarily. They interfered with judges. They devalued the currency and so forth. And this is where James Madison in Federalist 48 talks about all powers being drawn into the impetuous vortex of the legislature. So they had the suspicion of executives, but then after the Revolution and before the Constitution, they said, legislatures can also abuse power, and we've got to do something, take that into account. So when the framers built the Constitution in the summer of 1787, basically they accepted British individual rights and passed Magna Carta. There was a British Bill of Rights, Habeas Corpus Act, and so forth over the centuries. And a lot of the things in our Bill of Rights are taken almost directly from the English Bill of Rights of 1689. But what they clearly did was to reject the British structure of government with king in parliament or queen in parliament running the country. They decided, of course, on a separation of power system. But they wanted a government that would work, that would be effective with an independent executive that wasn't completely dependent upon the legislature. But they also realized that executive power had to be limited, and also congressional or legislative power had to be checked and controlled. And so they set it up so that ambition would be made to counteract ambition. Federalist 51, James Madison explains that, giving each part of the government the incentives and the ability to check power from the others, in which creating a sort of a delicate balance, very difficult to maintain, but in general we have done that pretty well in the United States. Of course, we had a civil war, but other than that, nothing's perfect. But But generally, it's worked, and the pendulum has sort of swung back. But I think in the 20th century, instead of a pendulum swinging back and forth, it's more like a ratchet in terms of executive power. And not for nefarious bad purposes, but because for all sorts of good reasons, national security, executives have control of the military forces, intelligence, and they run the country. And so it's understandable that they want more power. And of course, that's one of the problems, that the things that the framers were concerned about is that they thought executives continually want more power. And again, not because they're nasty, bad people, but because they want to fulfill campaign promises, they want to protect the country and so forth. So this is a natural sort of thing and inevitable. And so I think we need to worry about executive power because the Constitution is, worry about the Constitution, but the piece I'm focusing on is executive power. Because the Constitution is our establishing document. It establishes the rule of law in the United States, and it legitimates the use of power. So the police and the military and so forth, and other executive agencies exert power over all of us, and it's legitimated through the Constitution and the laws and so forth. So we have to worry about this and pay attention. Also, I think historically, concentrated power is abused. The framers of the Constitution knew their history very well throughout the history of the world, and you can just look around now. Executives often abuse their power, and how can you keep that from happening? And the Constitution is the way that we try to keep that from happening. And as Madison said in Federalist 10, enlightened statesmen will not always be at the helm. So if you're designing a constitution, you can't design it so that you figure there's always going to be a good person in charge and acting according to laws and so forth. You have to design it for the possibility that sometime there might be somebody who's in the chief executive who's not the best person, and so you have to be able to check that person. So if men were angels, as Madison said, you wouldn't need a constitution, you wouldn't need separation of powers, but they're clearly not. And so you set up opposing sorts of powers. And of course, judges and legislators aren't angels either. And so there's this ambition, and the Constitution was set up to sort of set countervailing powers against that. But clearly the framers, I think, were right. Executives want more power one way or the other. And I think in the 20th and the 21st century, this has become more clear. So I'd like now to shift to look at President Bush and then President Obama and take a look at some of the places where I think that they're pushing the edge of executive power. When they took office, President Bush and Vice President Cheney consciously sought to shift the balance back to the executive because they thought that Congress had overstepped its bounds back in the 1970s when they were reacting against the imperial presidency of Johnson and Nixon, the War Powers Resolution, the Impoundment Control Act, and so forth. There were a number of other laws that were passed to constrain the executive. And so, but Vice President Cheney thought that was going way too far, especially in Iran-Contra, where he was the head of the Minority Report that said, this is just politics, there's nothing about the Constitution involved here, when President Reagan spent money aided the Contras with money when the Boland Amendment, which forbade that in law, so directly breaking the law there. And Cheney says, well, this is just politics. The Democrats, of course, thought that it was much more serious than that. But since then, Vice President Cheney had wanted to be sure to bring back executive power to the presidency that he thought that had been usurped by Congress. Okay, so so they did this very consciously, but a number of specific cases, I think, pushed the law pretty far. In effect, President Bush suspended the law when he said that the Geneva Conventions did not apply to how the United States treated suspects or al-Qaeda prisoners. Geneva Convention said you have to treat them in certain ways, and on the 7th of February 2002, President Bush issued a memorandum saying we're not going to comply with the Geneva Conventions. They don't apply to these cases. One example. Another example, he asserted that his administration was not bound by the requirements of the Foreign Intelligence Surveillance Act, which said that you had to get a warrant before you were going to surveil people in the United States, wiretap, and so forth. And he went ahead and did that after 9/11. without bothering to get warrants, or technically they're called orders. And then clearly they could have gone and said, they said, well, there's technical problems here. They could have gone and tried to have it changed, but they didn't do that. They just went ahead anyway without the warrants required by the law. He argued that U.S. laws regarding torture did not apply to the president when national security was involved, and even argued that they were unconstitutional. Any constraint on the president dealing with prisoners was unconstitutional. He refused to recognize the rights of prisoners to submit habeas corpus appeal to the people in Gitmo, Guantanamo. And this was overturned by the Supreme Court in several decisions, Hamdan, and Boumediene, but President Bush tried to do that. And he used signing statements to an unprecedented degree. Signing statements are when a law is passed and the president signs them. Actually, a piece of parchment goes to the White House and the president signs them with a pen. And at the same time, the president can issue a statement saying, and usually these are sort of things saying, oh, this is a wonderful law. It's going to do great things for the American people. I want to thank all the people that helped get it passed, and all of those sorts of things, which is not a problem. But once in a while, a president will say, I think, instead of vetoing the law, will say, I think that part of this is unconstitutional, and I'm not going to feel bound by those parts that I think that are impinging on my rights as president. And so some presidents had done this a little bit in the past, but the total number of constitutional challenges and signing statements up to President Bush was about 600, and he issued 800 constitutional challenges, more than all the previous presidents combined. And I'll say a little bit more about this when I come to President Obama. So I wrote a book about those issues on the Bush administration, and then turned to the Obama administration, and some people thought, well, Pfiffner's book was just a partisan attack on President Bush and so forth, but the framers of the Constitution were right. Executives want more power, and so I've got some specific examples of the Obama administration, and I think that he has a mixed record with respect to this. I don't think he was anywhere near as extreme as President Bush was, but he came to office in a delicate situation. On the one hand, he wanted to distinguish himself from President Bush by sort of implying that he was not going to use executive power very heavily. On the other hand, he didn't begin with a blank slate. There were a bunch of fates accompli facing him when he came to office. And often presidents and their lawyers are very hesitant to cede powers to the other branches. So even if they thought the other previous president had gone a bit too far, they don't want to back off because they don't want to be remembered in history as somebody that gave up executive power to the legislature. This is very important to people who are lawyers in the White House, and it's important to presidents too. And so once a prerogative is asserted by a new president, it tends to stay there. That's part of the ratchet dynamic here. So even if President Obama didn't intend to use President Bush's claims to executive power, he feels bound to protect some of that. Now, I'm going to give you three exceptions first before I show where President Obama has gone a bit too far. One, with respect to enhanced interrogation, that is torturing people in interrogations. And the second day in office, he issued executive orders saying we're not going to do that anymore. We're going to comply with the Geneva Conventions, and the CIA can't go any further than the field manual of the Army in terms of interrogating people. The field manual in the Army is very clear. I went through basic training. We learned this stuff way back in the 1970s. You don't do some things. You don't torture people. You don't use coercion and so forth. And that was just drilled into us. And anyway, so President Obama limited the CIA also to those constraints. In general, he's tended to base his claims on executive rights to do things on laws, legislation, rather than his constitutional authority, which in a sense is a good thing. It's backing off saying I'm doing this pursuant to the law rather than I'm doing it because I have the executive power to do this. Interestingly, he did not use what I would say arguably would be an argument that he could pay, okay, remember the debt crisis, and was the United States going to pay people who had bonds, people that we owed money to, and there's a showdown in Congress, a crisis as to whether we would do that. Would we pass a resolution or that increase the national debt, the law that did that? And the 14th Amendment says that the United States debts, I've got the Constitution here, but I won't read it. But it says that the United States will stand behind its debt. So I think that President Obama could have said, the 14th Amendment says this, and I'm going to pay this money anyway, but he decided not to do that. So those are three sort of exceptions, but I want to shift now to some of the problems, more serious problems, I think, and the first four, I think, are more serious. One has to do with Guantanamo. Okay, so there's about 700 or 800 people there. By the time President Bush left office, there was about 100 left, and President Obama had a committee to decide what to do with these people, and it turned out that, about a third or a half of them were not problems, were not guilty, or would not probably attack the United States if they were released. Of course, Congress doesn't want to let him release any of those, and certainly not to bring them to the United States for trial. He said then there was another bunch that were guilty of crimes that we could prosecute. We could take them to court, and of course, Congress wants them to only use military commissions rather than Article III courts, regular courts in the United States. And the administration would rather do it in Article III courts, as the Bush administration did, but Congress doesn't want them to do that. Okay, so those people arguably could be convicted on evidence. But a number of them are left, I think about 30 or 40. And the probability is that they were guilty of doing bad stuff, but we tortured them. And so you can't use evidence gained by coercion or torture so they wouldn't get convicted. They would, the argument in court would be you can't use this evidence to convict these people. And so these people nevertheless might present real problems to the United States. They might go back, try to do terrorism and so forth. So arguably you don't want to let these people free. On the other hand, you can't prosecute them, and so you're stuck, in a sense, saying that you're going to keep them indefinitely without trial, which is the situation that we have now, which I think is very problematic. And there's no easy answer to that question, but it sets, I think, a bad precedent, especially if U.S. citizens are accused of aiding the enemy and so forth. With regard to that, the National Defense Authorization Act for fiscal year 2012, Section 1021, seems to allow the President or any person to be held without trial until the end of the hostilities authorized by the authorization for the use of military force in 2001. Okay, so this is pretty wide open. When is our war on terrorism going to end? It could be any time. So indefinitely, this looks like indefinite incarceration of these people, and the any person language seems to imply that a U.S. citizen could end up in that situation. Obama said he wouldn't do that to a U.S. citizen, but the point, that's in the law, and the executive can do it legally. So President Obama hasn't been breaking the law here, but this, in this case, the law allows it, and I think it's a dangerous precedent. Okay, shifting from incarceration, indefinite incarceration, to armed unpiloted vehicles, UAVs, drones. Basically, and these are drones being used outside of hot battlefields. Okay, so if you're in a battle and bad guys are shooting at you and there's a drone up there and kills those people, that's okay in terms of the rules of war. But if you're going to go find somebody who you suspect is plotting against the United States and then kill him, that's a different set of issues. President Bush only did about 49 strikes in his last year in office, but President Bush really ramped up the use of drones with about 400 attacks in Pakistan and Yemen, killing between 2,000 and 4,000 militants and about 300 civilians. There are different counts on this, but these are ballpark figures. So it's a serious use of it, the drones. The Department of Justice issued a white paper about the criteria to be using drones, and it said it had to be a senior al-Qaeda leader, careful vetting in the executive branch, that capture is infeasible, the consent of the host nation is there unless they are unable or unwilling to agree to a drone attack. Of course, if they're unwilling to, we do it anyway. So it's a pretty broad language. And the rest of the language, quoting here, it doesn't have to be somebody specifically plotting an attack against the United States. Quote, certain members of al-Qaeda are continually plotting attacks and would engage in such attacks regularly if they were able to do so. So this is pretty expansive. If the United States thinks somebody is plotting something bad, we can kill them. Now, of course, this is the legal justification, and I'm sure that the executive branch is very careful and so forth, but it doesn't publish its criteria other than those very vague ones. It doesn't report saying the reason we killed these people was that we had evidence that they were doing these bad things. And of course, there's a special problem with U.S. citizens being killed without due process of law. Extrajudicial killing, that I think is very problematical. It's been done to several people that used to be, that were U.S. citizens. So armed drones can be very useful. They can be used legitimately, but I think it's very problematical the way, both in policy terms and in legal constitutional terms, the way that they've been used. A National Security Agency, NSA, surveillance of Americans. Fourth Amendment, just to remind you, the people are to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and warrants must be based on probable cause. Okay, so in the you don't remember, but back in the 1970s, there was a thing called the Church Committee, which uncovered all sorts of abuses by the CIA and the FBI, surveillance of Americans and other things, really being abused for political purposes and so forth. So this was a big deal, and in part that was why they created in 1978 the Foreign Intelligence Surveillance Act to constrain the executive for surveillance in the United States. Outside the United States, basically, it's okay, but inside, you've got to get a warrant or an order from the Foreign Surveillance Intelligence Surveillance Court, which is set up by FISA, is the name of the acronym. Now, after 9/11, President Bush violated this. He told NSA to go ahead and do this in very secret sorts of orders that even, Mike Hayden, who was head of NSA at that time, a colleague of mine, the Vice President's attorney, David Addington, wouldn't even let him see the legal justification for what he was being ordered to do. And so this is how secret it was, that the people who were carrying out couldn't even see that, and his counsel couldn't see it either. Okay, so the Bush administration did this, and then later they got these powers got locked into law, and there's some problems with this, and especially with Edward Snowden's in 2013 in June released a whole bunch of classified documents that showed the extent of electronic surveillance and data collection on persons in the United States. And so, most of the collection of intelligence is legitimate. It's important. We want to do it. It's for our security. But there are three programs, I think, that are really problematical here. One is Section 702 of the Foreign Intelligence Surveillance Act, which is collecting the content of information. What you say on the phone, what you write on email, and so forth. And that generally has been, okay, there's a Privacy and Civil Liberties Oversight Board created in the executive branch by law. Independent bipartisan agency came to the conclusion that the programs were clearly authorized by the FISA statute, so that's a good thing. But the large scope of incidental collection, and I'll explain what that is problematic. The use of about collection, that is when you are searching a database for something about a person, and using queries to search for specific U.S. persons. Okay, so you've got all of this surveillance of foreign potential, bad people trying to do spies things for the United States, but you also pick up incidental communications. For instance, if there's a foreign person communicating with somebody in the United States, incidentally, you're going to find out all this information about the person in the United States without, and of course you have a warrant for it, and that's not a problem. If they go and say, look, we suspect this person's doing bad stuff or is a spy or something, no problem, you get a warrant. But they gather up all lots of information on U.S. persons that are incidental to focusing on somebody who's foreign. Now, NSA is supposed to minimize information about U.S. persons. That sometimes happens, sometimes does not happen so much. But Snowden's showed that there are thousands of communications of Americans were being kept in NSA databases, and so that's kind of problematic. Connected to that is Section 215 of the USA Patriot Act, which allows NSA to collect metadata. Metadata from virtually all telecommunication companies and phone records in the United States, which metadata is time and place of call, recipient, duration of the time, location, email, IP, internet protocol address, websites that were visited, and so forth, which does not include content. And so you think, well, content is really a lot more substantive, but nevertheless, metadata can be very revealing. Hayden said in an interview, basically, this is very informative stuff. Quote, "We kill people based on metadata, but that's not what we do with this domestically acquired metadata. It's really important to understand the program in its entirety, not the potentiality of the program and how the program is actually conducted." Okay, so but that's the real problem. What people are concerned with, even if you posit that nobody in the Bush or Obama administration is abusing this, doing anything wrong with it, the problem is that in the future it might be. You've got this capacity there, and you've got all of this data, and what is there's no external check to the executive branch. Now, there's lots of procedures about who can query the database and so forth, but those things, that's the way it's written. That's not necessarily the way things always act. The Privacy Overboard that I mentioned commented on Section 215, and they're very critical of it. And they said, basically, the argument is that essentially the entire nation's calling records are, quote, relevant to every counterterrorism investigation. This position is untenable. Moreover, the interpretation is dangerously broad. So this is the stuff that all the metadata of all the telephone calls in the United States, they're sucking up and putting into a large computer. Basically, this looks like a general warrant or a dragnet. Instead of focusing on somebody or a group of people that you think have some suspicion are doing bad stuff, let's just get it all with the argument that, if you're going to find a needle in the haystack, you have to have a haystack to find the needle in, and so let's gather all of it. And I think that's problematic. Congressman James Sensenbrenner, who is on a supporter of the Patriot Act, said Congress didn't intend that or expect that to happen. So that the Oversight Board said that this bulk collection should be stopped. They also said that it had minimum value and that we had testimony from NSA people, have not identified a single instance involving a threat to the United States that was thwarted by the metadata. Okay, so here's a program that really doesn't do too much, but it nevertheless has the potential for somebody to abuse it in the future. So they recommended that be deleted, and there are bills in Congress to try to do that. Nevertheless, it's still going on. The third thing is Executive Order 12333, passed signed by President Reagan in 1981, which has to do with foreign intelligence. Now, that is not such a constitutionally delicate sort of thing, but it allows NSA to collect information that's outside of the United States. The problem is that a lot of the internet companies, phone, all sorts of internet communication and so forth, have backup systems. And some of those backup systems are in foreign nations. And so NSA can go to those external, U.S. Communications stored in a foreign nation and collect that. And so that's a problematic thing, too. And, it's difficult to tell whether this is being abused or not, but nevertheless, it's a capacity, and they have been collecting the data. So the defenders of collecting this bulk data argue that, there are rigorous executive branch constraints, internal constraints about who can use the programs, how they can be queried, and so forth, and they're not used for illegitimate surveillance of Americans. Now, that may be so, that we're not doing that right now. And there are lots of constraints, as I've been reading these regulations and laws and documents. There's lots of very careful things. The problem is those are just what's written down as opposed to the practice of this. And the critics of the program say they'll concede that they may not be being used now, but in the future, politicians like Lyndon Johnson, Richard Nixon, the people that the Church Committee found abusing surveillance. Somebody could, in the future, either for high-minded purposes of protecting the country, our national security, or for low-minded kind of partisan political purposes, could abuse this data. And we've got, plenty of historical examples to show that concentrated data, concentrated power can be abused, and that's one of the things that I think that the Constitution is concerned with protecting. War powers. Okay, President Truman set a really bad precedent in 1950 when he decided to go to war in Korea without asking Congress for a declaration of war. Terrible, unfortunate. And so this, of course, has been pushed by different presidents. 2007, Senator Obama was asked about this, and he said, quote, "The president does not have the power under the Constitution to unilaterally authorize a military attack in a situation that does not involve stopping an actual or imminent threat to the nation." Well, of course, there's been several situations, and the question is whether those threats are actual, an imminent threat to the United States. In Libya, President Obama justified that as a humanitarian crisis to support NATO forces and to use drones to support them in Libya. When the 90 days were up, and I'll go back to that, of the War Powers Resolution, he said that the U.S. was not involved in hostilities since U.S. troops were not on the ground and at risk. Okay, where the hostilities comes from is a War Powers Resolution passed in 1973 to constrain the imperial presidency basically in response to Vietnam, which says that the president can send U.S. forces into combat or into situations where imminent involvement in hostilities is clearly indicated by the circumstances, only pursuant to a declaration of war, a specific statutory authorization, or a national emergency created by an attack upon the United States. Okay, and so in that case, the president shall consult in every possible instance before committing U.S. troops, and it requires a report to Congress within 48 hours. And if those forces are committed and there is no declaration of war or no approval by Congress, the president is required to withdraw those troops within 60 days or 30 more days if the president certifies that that's important for our national security. Of course, that no president has admitted that that's constitutional. They argue they report to Congress consistent with rather than pursuant to the War Powers Resolution. Okay, Syria, President Obama decided to back off and ask for congressional approval. Of course, that never came. We didn't go into Syria at that time. But with ISIS now in Iraq, the administration is arguing that the authorization to use military force in 2001, which was about al-Qaeda, justifies it. It sounds like that's a bit of a stretch. ISIS is not connected anymore with al-Qaeda. Is it threatening the United States directly? Arguably not. But degrading and defeating ISIS with air attacks, and now they're talking about ground troops. Just General Allen and Chief Staff Dempsey, Chief of the Joint Chiefs of Staff Dempsey, started talking about using ground forces. This does not look to me like it's covered by the authorization to use military force of 2001 or 2002. And so, of course, Congress is not blameless in this. It's abdicated its role of checking the executive branch. And the problem, of course, is that Congress doesn't want to stick its neck out, individually or collectively. It wants to let the president make the decision, and then if it's popular and we have a successful war, they say, great, good going. If it turns out to be unsuccessful or unpopular, they want to say, you didn't get our permission, you shouldn't have done that, and so forth. So members of Congress are complicit in this. Okay, problematic issues, stepping back from those four really major things. One, recess appointments. The original purpose of the Recess Appointments Act, Congress wasn't in town all the time. You had to ride horses long ways to get in. And so if there's a vacancy in the executive branch, the president and Congress was not in session, the president could make a recess appointment on his own authority, which would get up at the end of the next session of Congress. Okay, and so throughout the history of the United States, presidents of both parties have used this, an intra-session recess, intra, meaning during a session, so August vacation or something like that, a Christmas recess, and they've made recess appointments. But none of them has done it with a recess of less than 10 days. Okay, so during the Bush administration, the Democrats in the Senate didn't want President Bush to make recess appointments, and so every 3 days they would have a member of the Senate go in, gavel the Senate to order, a minute later gavel it out of order, so that they could say that Senate was really in session. Of course, this is just sort of pro forma, but President Bush did not try to do any recess appointments during that time. He respected it, basically. But President Obama was getting very frustrated, and on January 4th of 2012, he declared 4 recess appointments on January 4th during a 3-day recess when there were these pro forma sessions were going on, and of course people thought that that was a bit marginal. Company Noel Canning went to court to argue that there was a decision by the National Labor Relations Board affecting them, and they said, wait a second, that's not legitimate because the board didn't have a quorum because these people were not confirmed by the Senate. The recess appointment was illegitimate, unconstitutional. Basically, they were right. The U.S. Court of Appeals for the District of Columbia agreed with them, and the Supreme Court agreed with them also. I think the Supreme Court was right, justifiably rejected it. I think Obama just pushed it too far. He shouldn't have done it, but he did. Signing statements, as I mentioned before, Obama said that he wasn't going to use them very much and only in narrow cases, but he has used signing statements, basically, saying, I think that this portion of the law is unconstitutional or it conflicts with my executive prerogatives, and I may not. I'll interpret it the way that I want to. And so the problem here, of course, is that it's possible for the president to get around a veto. So if the president doesn't like something in law, the Constitution says you can veto it, but the veto, of course, can be overridden. And this could easily be an attempt to do that, to get around that. But it's very difficult because, it's problematic. Sometimes presidents are right. Congress is going too far. But anyway, so that, I think, is something that has to be watched, but there's no easy solution to that. Executive privilege. President Nixon said that it extended to the entire executive branch. Of course, he was wrong on that. Because executive privilege is confidential communications to the president by lawyers, advisors, and so forth, which has to be frank. And they can't be frank if it's going to end up in the Washington Post the next day. So it's a reasonable sort of constraint. But presidents have used this, tried to push it further than the presidency. President Obama, in this fast and furious issue of arms and drugs in Mexico, argued that the Justice Department's, the whole entire work file of the documents in the Justice Department and executive privilege, it therefore extends deep down into the executive branch. I think he's wrong on that. I think he's pushing it too far. Professor Enton has written on this, his scholarship on this, and will probably say some good things, have some good insights about executive privilege. He's an expert in this. State secrets privilege. This allows the government to prevent sensitive national security information from being made public at a trial. Okay, so somebody goes to sue the United States government about something, and the government says, there's some national security, potentially dangerous information that might be released at the trial. We're going to assert the state secrets privilege. And so then judges back off and say, okay, we're not going to hear any part of this. And President Bush used this when people sued about being tortured, rendition, and so forth. And so, a lot of things that might be legitimate cases in court don't even get a hearing at all. President Obama has done that also, both with respect to the Bush trial or charges about the Bush administration, but also with respect to the Obama administration, and even with respect to civil suits. So if a contracting company is going to get sued for breaking the law or doing something wrong, and they've done some security stuff, all they have to do is say, okay, we're going to call up for evidence, we're going to subpoena all these documents, and they're all classified, and the executive branch said, no, we can't do that, and so the company gets protected by the executive branch or by the president asserting state secrets privilege. I think just a couple of days ago, a judge said, wait a second, we're going to look at that stuff, and the judge is going to make a decision as to whether it's really sensitive, which I think is the right thing to do, but of course it's going to be appealed. So I think both administrations have pushed that way too far. Okay, minimal things in terms that, ironically, I think the things that Republicans want to impeach President Obama on are the least problematic of all. It's not all of those. It's not all of the other things. It's the Affordable Care Act, and is it being faithfully executed because President Obama gave a 1-year delayed the employer mandate for 1 year, and to ease the transition to the new law and so forth, simplify reporting requirements. And the question is he trying to undermine the law and not faithfully carry out the law, or is he using reasonable discretion to say, okay, you have 1 more year before we start enforcing this? He didn't say we're not going to enforce it. He said you have 1 more year. And that seems to, and of course, President Bush did this with the Medicare drug benefit. And other presidents have done it too. I think that's trivial. I don't think it's serious. I think that's a reasonable use of executive discretion. 1 more, the Deferred Action for Childhood Arrivals, DACA. The DREAM Act, of course, failed to pass Congress, and so the president said, we're going to prioritize. You've got thousands of people down in the border. We're supposed to deport those that shouldn't be here, but he says we have to have some priority, and so we're going to throw out first people with felonies who have repeated border crossings, who present security threats, risks to the United States. Take those people out first, and we're going to delay for 2 years people that came in the United States when they're 16, been here for 5 years, have a high school degree, have not committed a felony, and so forth, and saying, okay, we're going to do these people first. We're not going to let these people stay here forever, but we're going to delay that for 2 years. And I think that's a reasonable sort of administrative use of administrative discretion. Okay, one final, I got a conclusion. Final point, Sergeant Bergdahl, Obama did break the law by not giving 30 days notice to Congress. I think he broke the law, but it was legitimate, and he should have said, yeah, I broke the law, but I had to do it to save this guy's life. So in conclusion, I think the Constitution provides legitimacy for the exercise of sovereignty and coercive power in the United States. The principles are crucial: the separation of powers, individual rights, equal protection of the law, but as Madison said, these are parchment barriers. That is, the Constitution is self-enforcing. It takes an engaged citizenry, like the people around here who pay attention to these things, Republican virtue in elected officials, and toleration of opposing political views. So Benjamin Franklin's admonition still holds. He was asked when he left the Constitutional Convention whether they had created a monarchy or a republic, and he said, we have a republic if you can keep it. Thank you.
Thank you, Professor Pfiffner. And now we'll hear from our discussant, Dean Jonathan Enton of Case Western Reserve University School of Law.
Thank you, Caroline. And first, thanks to the group for inviting me to participate, and thanks to Professor Pfiffner for a really wide-ranging discussion. I'm the House lawyer, so I guess I should begin by pointing out that Professor Pfiffner hasn't had a whole lot to say about what courts have done. There is a large reason for that, namely there isn't all that much judicial or jurisprudence on some of these issues. There is some, and I want to come back to that. But I want to make a couple of other points here first. For the most part, Professor Pfiffner has spoken about issues relating to presidential power in the military and diplomatic arena, where whatever people's view about the appropriate scope of presidential power, there's general agreement that the president has probably more power, more discretion in those areas than in the domestic sphere. Now, there are cases, as Professor Pfiffner mentioned, in which the president, even in those areas, has had his wings clipped. Hamdan, Boumediene.
Yeah.
We can go back to the steel seizure case during the Korean War. But those are among the exceptions, and to some extent, those rulings and some of the rulings on the domestic side have resulted from really aggressive legal positions taken by executive branch lawyers who might have had better judgment to make narrower arguments that were more crafted to the particular controversy in hand. So that's one thing. Second thing to keep in mind is even in the foreign affairs, military, diplomatic area, as Professor Pfiffner indicated, the president was not acting unilaterally. Congress was complicit. If we think that the president has asserted too much authority, after all, the president didn't pass the Foreign Intelligence Surveillance Act. The president didn't pass the resolution authorizing the use of military force. The president didn't pass the USA Patriot Act. In other words, Congress, to some extent, has defaulted, has effectively delegated extraordinary power to the president. That doesn't necessarily mean that this is a good thing, but I think it at least should give us some perspective on what we're dealing with. Now, let me just quickly pick up on a couple of other things because I want to open this up for discussion fairly quickly. One has to do with the state secrets privilege, which the executive branch has asserted quite broadly. But it's a privilege. Courts have to pass on the scope of the privilege. There is certainly good reason to wonder whether courts have taken the right path in this area, but courts have pretty consistently upheld the state secrets privilege for just about all that it might be worth. Any lawyer worth his salt in the face of rulings like this is likely to say, fine, let's push this argument for as much as we can. Last substantive area has to do with recess appointments. Again, President Obama pushed the envelope on this, and it is true that the Democrats in this instance sort of got hoisted by their own petard. After all, it was the Democrats who invented these pro forma sessions to frustrate President Bush. But as Professor Pfiffner indicated at the outset, the framers gave us a government that was supposed to be workable. Part of the frustration here that led the president to push further than might have been legally advisable was the sense that the Senate wasn't doing its constitutional duty either. That is, the Senate could vote these people down. Of course, the reason that this was happening was because there was a majority in the Senate for confirming these folks. That also explains the so-called nuclear option. That raises a whole series of questions about ambition being made to counteract ambition, giving each branch the institutional motives and means to protect their interests. That gets us to a whole wide range of issues that go well beyond what Professor Pfiffner was asked to get into here, so I don't mean that to be critical. But if I were to summarize where all this is going, one, although I can talk all afternoon if you want about separation of powers and presidential power jurisprudence, that would put everybody to sleep, even me. Second, it seems to me that litigating a lot of these issues is probably not good for the system, even if courts might come up with reasonably consistent guidelines and rules, which they haven't done. Instead, I think I would leave you with the observation of learned hand in a celebrated essay on the spirit of liberty. That we sometimes think that we should put our faith in laws and courts and the Constitution. But he said, these are false hopes. When the spirit of liberty dies in the hearts of the people, no law, no court, no Constitution could save it. If there's one thing to be said for Senator Byrd's requirement that we have a program like this on Constitution Day, it is to help to reinforce that message from learned hand. Thanks.
Thank you, Dean Enton. And now our student panelists have a few questions for Professor Pfiffner.
In the past, presidents have commanded Americans to act in ways considered inappropriate and even atrocious. Examples like the forced movement of the Cherokee Indians under President Jackson and the internment of Japanese Americans under President Roosevelt come to mind. Professor Pfiffner, why are such commands followed?
Okay, good question. I think because, in part, people are afraid, and they may see it as a national security thing. So Native Americans may be seen as a threat. Japanese Americans may be seen as potentially subversive and so forth. So people are afraid. The military is pushing to do these things to protect national security. Those are compelling kinds of arguments. They're appealing kinds of, I would not say, not compelling, appealing to lots of people. Okay, and the president is commander-in-chief, and so if the president says, do this, the military in general is going to do it. Now, you know, the good thing about that is that we've got civilian control of the military in the United States, and that's the way it should be. And so you don't want the military making these decisions. You want them to do what they're told to do. The problem, though, is that some presidents, and this is truly the case with the torture issues, the career military people, and I wrote a book about this, I've got the evidence that they objected to this. They said, you know, this is wrong, it violates Geneva Conventions, we shouldn't do it, you know, it's immoral, it does not work, and it's going to make us look really bad, and it's going to threaten our own soldiers. Okay, so the military people and the career civilians objected to this, but the civilian leaders, in this case, insisted, and they got their way. And so it's a combination of, I think, fear in the populace, the discipline in the military, bad decisions at the top, and not enough countervailing political flack from people who disagree. And so if elites are split, like the other political party is saying, no, you really shouldn't do this, this is a bad idea, then you've got some kind of constraint. But often the other political party or Congress is unwilling to step up and take a risk, and the president will say, this is absolutely important for our national security, and if you don't do it, your blood is going to be on your hands. And so politicians don't want to do that. So partly it's cowardice, partly it's fear. It's unfortunate, but in the real world, that's the way people often act.
Let me just add one quick observation about the internment of the Japanese Americans. The orders to intern the Japanese Americans didn't come at the very beginning of World War II. It came after the war was underway for a while. And one of the most vocal advocates of interning the Japanese Americans was the then Attorney General of California, a fellow named Earl Warren, whom some of you might have heard of. When we are in war and we are facing the prospect of really serious harm to the nation, sometimes people will exaggerate the risks that other folks pose. It's easy in hindsight to second guess what happened. This is not to say that, therefore, this was right. We know that in hindsight, that the internment of the Japanese was one of the great stains on the nation. But a lot of what has happened that Mr. Winters mentions came about in similar circumstances. And if we were all as moral and insightful looking prospectively as we are retrospectively, the world would certainly be a better place.
I agree, and I want to just add a point on the hindsight thing. That's true. When you're stuck in a situation and it really looks terrible, you do something that you might not ordinarily do. But with respect to coercive interrogation, that's one of the things that I was very careful to look at, and because right after 9/11, people throughout the United States and certainly the government were just terrified that there was going to be a second attack, and so in that situation, even though it might be wrong for the president to allow in a coercive interrogation, thinking that it would help the country or protect us, might be understandable. But with the Bush administration, they continued to argue that throughout the whole administration, so it wasn't like just in the heat of the fear immediately afterwards, but they kept it up. But I think that that's a legitimate point that we have to ask that question. Thanks.
Unilateral executive actions have occurred throughout U.S. history. For example, President Lincoln's suspension of habeas corpus during the Civil War. In a New York Times article, Robert Dallek named two more: President Roosevelt's provision of military supplies to the British without congressional approval, and President Kennedy's order integrating federal public housing. He called these actions, quote, wise and effective, end quote. Professor Pfiffner, could these examples justify future unilateral actions?
Okay, excellent point, and this points out the importance of precedent. And sometimes you would like to say, well, this is a good president doing the right thing, and so we should go along with it and say that it's okay. And so you might, so Lincoln and habeas corpus. In April of 1861, he thinks it's important for the security of the country. He suspends habeas corpus. But the difference there, I think, which was clearly unconstitutional and illegal, but Congress was out of session. When Congress came back in session in June, he went to Congress and said, look, I did this, I know it was wrong, or unconstitutional, but this was to save the Union, and I felt that I had to do it at the time and asked for the retrospective approval. So if a president has to do something that is clearly beyond the law, okay, George Bush after 9/11, shut down all air traffic in the United States. Now, where in the Constitution and the law does it give the president the authority to do that? It doesn't exist. But everybody knew that it was a reasonable thing to do. Nobody objected. Nobody said, hey, we're going to impeach you because you did this. It was clearly, it was seemed to be necessary. So I think that if presidents need to do that, or do something like the 30-day suspension, which is a minor thing of Obama when he traded for Sergeant Bergdahl, did not notify Congress. I think he should have said, yeah, I did it. It was against the law, but it was the only thing the only way I could accomplish saving this guy's life, and therefore it was legitimate. FDR and the Brits, he did push things a bit further, and in retrospect, that looks like it was probably a legitimate thing to do, even though technically it may have been wrong. And the problem then with letting good presidents doing wise things against the law, the problem is that it sets a precedent, so then in the future other presidents can point at that like they did at Lincoln and say it's okay to do it because Lincoln did it. And so those are very difficult issues, but that's, I think, one of the real problems with precedent, is because when good presidents do it for good things, potentially less good presidents will use that as an excuse to do other things, and so it's dangerous. No clear answer to the question.
In his 2014 State of the Union address, President Obama expressed his intention to act without legislation. He said, quote, wherever and whenever I can take steps without legislation to expand opportunity for more American families, that's what I'm going to do, end quote. He was subsequently criticized for violating the Constitution. However, the president's comments came after months of partisan gridlock in Congress. Professor Pfiffner, how does divided government affect presidential power?
Okay, well, it affects it a lot. I think in that statement, the key is what he did and how the law reads. And so if he says, I'll do everything that I can within the law, that's okay. And I gave you a couple of examples where I thought he was acting within the law reasonably, and that's okay. But say on the immigration thing, if after the election he does something that clearly violates the law, I say that that's, I would advise him not to do it. Divided government, I think, what I think Madison and the framers did not foresee was the nature of political parties in a polarized system. And now our system is so polarized that Congress is stuck in gridlock and won't do things, pass budgets and the normal sorts of things that ought to happen, arguably, to take care of important public policy issues. And this tempts presidents to exert power beyond where they should. And you can understand the frustration. You can understand the frustration of President Obama with not even get a chance for up or down vote, as you pointed out, on his confirmation or on his nominations. But I still think that it's important to obey the law and Constitution as much as possible, because if you don't, even if it's arguably legitimate, you set precedents for other presidents who are, not the statesmen that Madison talked about, to use that as a precedent. So I would be very conservative in allowing presidents to push further than the law or Constitution would allow, even if it's, arguably a legitimate case, because it sets precedents that other presidents can use in the future to violate laws in a much further way.
We ought to keep in mind that the Constitution, with its system of checks and balances and divided power, was designed to make it hard for things to happen. That's the default is no. Right? You have to get a piece of legislation through both houses of Congress, and you have to get the president to sign it. If the president vetoes, then you have to get a supermajority in both houses. That gives a minority a lot of power to obstruct. We've had divided government for extended periods of our history, and sometimes some remarkable things have come out of divided government. We've talked about President Nixon in connection with Watergate, but a lot of the domestic initiatives that President Nixon undertook would be almost unthinkable today, at least in the Republican Party. As Professor Pfiffner points out, the parties themselves are so polarized that there isn't much of a middle for members of Congress to work with, or for the president and the president's staff to negotiate with on the other end. Divided government may reflect our ambivalence, but the fact of divided government doesn't necessarily mean that there's something wrong with the system, although those of us who might have strong views on one side or the other might think that there's something really irrational about all those folks who don't see it our way.
I'd like to add, in agreeing with you mostly, but I think the framers did, in moving from the Articles of Confederation, they created a system that would work. They wanted it to work. They didn't have an executive with any power, so they wanted to have an executive, and they wanted to have enough central power for the government to actually work. So agreed that you have to get through all those veto points and so forth. It's difficult, but I think they did want it to work. And I think your point about divided government is a good one. And back in the 1970s, a lot of the liberal legislation that we think of in Johnson-Kennedy years was passed under Nixon, which is counterintuitive. That was divided government, but of course then you had political parties that really crossed over ideologically in the middle, and you could cut deals across the aisle. Now it's much worse because it's polarized in a way that's much more difficult, which I think that the framers didn't foresee, but there's no solution for it. I'm not saying that we should change the Constitution or anything, but I think the polarization is worse than divided government.
One quick story that illustrates how much things may have changed. Strom Thurmond served in the Senate until he was 100 years old. He started as a Democrat, and he switched parties in 1964. On the night that he was going to announce his party switch, Roger Mudd, who was the CBS News congressional correspondent, came on the evening news with Walter Cronkite and said that Senator Thurmond was going home to announce that he was switching parties. And then he said, when asked for his reaction, a prominent northern liberal Republican senator, not named, but uttered an earthy phrase. When asked for a quotation for the record, the senator replied, "That's my quote, folks, take it or leave it." It is inconceivable that such an incident could take place today because the parties have become much more polarized than they were 50 years ago.
Yeah, and just one more point about, speaking of Strom Thurmond and the filibuster, which is not in the Constitution, but he set the record for a filibuster, and it was against, of course, the Civil Rights Bill, and it was 24 hours, which is, but the broader point here is that the filibuster is not in the Constitution as is another one of those constraints that the Senate goes along with. And so you couldn't argue that it was intended by the framers, but just another dimension of that. Go ahead.
Thank you, Dean Enton and Professor Pfiffner. And at this time, we'd like to welcome questions from students, faculty, staff, and other guests from the audience. Please raise your hand if you have a question, and we'd be more than happy to bring the microphone over.
I'd like to follow up in terms of the framing of the event. First of all, thank you to everybody. But so the notion of the president on his own and executive overreach. First of all, there's two ways you can be on your own. You can be doing something that the rest of the system is against, or you can be doing something that the rest of the system would prefer that you do and they not take the blame. And it seems to me that most of the cases that we talked about where the president is doing something that maybe somebody in retrospect would say maybe wasn't quite constitutional, a lot of this is, as you said, basically accepted by majorities in the country. Majorities are quite happy to lock up the Japanese. Majorities are quite happy to drive away the Cherokees. The majorities are quite happy to torture Arabs. You know, that's just the basic attitudes in the country. So that's one case where the president is on his own, but he's not really on his own. Right? A second case is where the president is on his own because he does nothing, because there's something he feels he has to do, and there's no way to get there, and it's maybe not all that popular. But I'm looking for cases where it's really something big, where the presidents are overreaching, going out on their own in a way that's actually big, and it's hard to think of them what they would be. And then the third situation is the executive branch does something, and maybe Congress or the courts have problems with, but you got to wonder if it's really the president. And there's a lot of that in some of what you talked about, which is the NSA. I don't know whether the president actually knew what the NSA was really doing. I don't know if they really told the president what they were doing. And so. And some of the other things, like the Halbig case, which is a claim that the president decided to award benefits through the federal exchanges, looks to me like a typical administrative decision that a bureaucracy would make. So I guess my question is, can we really think of examples in which the president, on his own, went off and did something important that the rest of the political system really disapproved of?
Well, I think that the problem is one that Madison pointed out, which is the tyranny of the majority. And so a majority of people may be in favor of massive surveillance of Americans or torture or whatever. But the Constitution is intended to constrain that with laws in the Constitution, Bill of Rights, and all of that stuff. And so I think that you're right. Often a majority is in favor of some things, but the president doing that doesn't justify it. The majority can't justify it. We've got this due process, the constitutional policy process, and so forth. I think your other point about the executive branch and the pressures there are real, in the sense that Senator Obama, looking from the outside, was very critical of President Bush. But once he gets on the inside, it seems things look a little bit different. In the old saying, "Where you stand depends upon where you sit." And I think with NSA, that's one of those things, is because he's getting all of this intelligence, and there's all of these threats and something, and he's got to, he's in charge, and he's going to get blamed if there's another attack and so forth. And so I think there's a lot of consensus in NSA and the intelligence community that these things are really important, and so it's difficult for a president to back off on that. And it's a similar thing with the military. If they say this is really important, we've really got to do this to protect the United States, the president and the White House staff certainly have a lot of discretion, but they also pay very close attention to the professionals that do this all the time, and that sort of, in a sense, peer pressure, social pressure, whatever, consensus on the part of the people that are doing it, I think is a very powerful thing. And so presidents can't always resist something that maybe they should.
Yeah, I think it's also worth pointing out that the president can't do all that many things on his own. There is another wonderful line attributed to Harry Truman in the beginning of Richard Neustadt's great book on presidential power. During the transition period after the 1952 election, Truman says something to the effect that Eisenhower is going to come in here and he's going to say, do this, do that, and nothing will happen. Poor Ike, it won't be a bit like the Army. But ultimately, the president is politically and often, in a sense, legally responsible for the actions of the executive branch, even if you can't clap the president in irons. And yes, this notion that we have a unitary executive branch where everybody's pulling in the same direction is really kind of a nice image, but almost every president, at least in the last century, would tell you that the bureaucracy was actually the bane of their existence.
Yeah, I think you point out that accountability is crucial. And so even, the president is in charge. There is a hierarchy. And so somebody has to be in charge, and the president is it. Now, if somebody way down low does something that's bad and the president disowns it, people don't blame the president. But if it's part of the president's policy, he or she is in charge of that. And of course, presidents do have problems with bureaucracies, but if they, and this is one of those things, if the president wants it done, he can say something, but then he's got to follow up, or Bob Haldeman or the chief of staff, somebody has got to make sure that it happens. So the presidents can overcome those things, but it's not immediate, like you said, that everybody jumps when the president makes up his mind.
You gave a lot of examples earlier today, and talks about presidents stepping out of their bounds even before the last 15 years, but kind of what I got a lot out of it was the last 15 years have been different from what we've seen before, that there's been a skyrocketing in executive power, and you talk a lot about precedent and how presidential actions build precedent over time. So do you think this new situation we've seen in the last 15 years is an unavoidable reality for politics in the future? Is it something that we're going to see from every president that comes afterwards, or would these last 15 years be an anomaly?
Well, I think the pressure is always there on executives. So the framer said executives want more power, and that's inevitable. Some presidents are less assertive than others. But I think the Bush administration, in those examples, pushed things further than they had been pushed before. And due to technology, now the war power itself is something that presidents have always had an edge on. Harry Truman particularly, but presidents since then. But I think that there's been some important changes, in part because of the technology of NSA, and partly because, with the whole Cold War and the need to make national security decisions quickly and so forth. And so I think it is inevitable that executives are going to want more power, but it's not inevitable that the political system is going to allow them to go further than they should. But the only counterbalances are what Congress and the courts do, and citizens in terms of their own representatives and so forth. And so it's sort of like a warning that it's inevitable that there's always going to be this pressure, but it's crucial that there be a counter pressure on the part of Congress and citizens and the courts.
You could answer these questions real briefly. The use of special advisors in Latin America, can that be circumvented in terms of the War Powers Act? The second one would be a situation what happened in Libya in terms of NATO and that particular situation. Can that extend the presidential executive powers? And how far-reaching are executive powers? And the last question would be, in terms of Central Intelligence operations, in terms of special operations as an attaché to the military special operation groups, is that a circumvention of powers in terms of initiating actions within these particular spheres of influence?
Okay, a series of good questions, important questions, and I can speculate a little bit. I think some of the stuff we've been doing in Latin America is a bit marginal. Hiring contractors and saying the U.S. troops are not involved, using special forces in a secret way. That is kind of, and getting to your last point about the CIA, special ops and so forth, covert actions. Now, presidents can do covert actions by signing a finding, and that's basically secret, and so it's very difficult to check that. And they can, if it's a special operation or a covert action in pursuit of a policy that's a clear policy, like we're trying to undermine the Russians taking over the Ukraine or something, that's more legitimate. But presidents can do those things that are less legitimate, and if it's secret, it's very difficult to tell. Libya, of course, the excuse was it's humanitarian. It's NATO that's really doing it. We're just sort of supporting them. I think that was pushing it a bit. And so there are a lot of executive practical things that presidents can do because they have the secret ability to give orders to the Army, the CIA, and NSA that may violate, what we think of as laws, but it's very difficult to constrain that unless you have somebody blowing the whistle or you have Snowden dumping a whole bunch of secret.
In the 80s, they were used within the Latin American countries, what we would call Green Beret or recon, Navy SEALs.
Sure.
But they were classified as an advisor within a combat situation. What does this classification mean within the sphere of executive power?
I think in the spirit, it violates it to say that these people are just advisors, and when in fact, if they're engaging in combat and so forth. And so, but the problem is that it's often secret and it's difficult to constrain. So if somebody in Congress then makes a big deal of it and says, we're going to pass a law that says, no more money, no money to the Contras, then it can be a big deal, blow up into Iran-Contra. But if Congress doesn't do that, it's difficult to get other people, other parts of the government to say, hey, this is pushing things too far. They should be using the War Powers Resolution, or they should be doing, or the president should be doing it more publicly, and the president's not. So, it depends on what the political counter pressures are, and whether presidents are willing to keep up with the spirit of the Constitution and the War Powers Resolution. Good points.
Professor Pfiffner, in a 2007 article, you used Federalist 47 and the quote to say, "The accumulation of powers, of all powers, legislative, judicial, and executive, in the same hands, whether of a few or many, and whether of heredity, self-appointed, or elected, may justly be pronounced the very definition of tyranny." However, in Federalist 47, Madison goes on to explain how Montesquieu viewed a violation of the separation of powers as a canceling of the other government's or the other sector's check on the executive. So would you continue to argue, in light of Montesquieu's view, that Federalist 47 serves as an accurate measuring stick to determine whether a president has violated the rule of law?
Difficult one. Okay, so Madison was sort of saying, I think exaggerating, if you concentrate these powers, it is tyranny. I mean, I think the point is it could lead to tyranny if there's no check. And Montesquieu sort of argued that if you separate powers, they should be able to counteract checks and balance and so forth. So I guess I'm not sure how to answer that question, except to observe that they both sort of believed that separation of powers would help constrain concentrated power to ward off tyranny. But Madison also said that these are parchment barriers, and it depends on the behavior of the people in these offices to actually use their constitutional checks and balances.
This is not just a conceptual issue. We have a large body of law. I teach a course called Administrative Law. We have agencies, some of which are in the executive branch, some of which are not, that in one way or another might seem to be exercising executive, legislative, and judicial powers all at the same time. We also have a very elaborate set of statutory rules and customary practices informed by notions about due process under the Constitution that are designed to mitigate the likelihood that any one piece of an agency will accumulate all of these powers. And most agency action is subject to judicial review. Now, granted, a lot of judicial review is relatively deferential, but there are judicial checks in those situations. There are often political checks because Congress has the authority and often uses it to try to clip agency wings. And so even with the concern that the agency may have accumulated excessive powers, there are, at least in theory, some mechanisms to mitigate that. People can and do disagree about how effective some of those mechanisms are, but those mechanisms are out there anyway.
Ladies and gentlemen, we'd like to thank our contributors for this program. Please join me in extending a special thanks to the Office of the President and Provost, the Office of Government and Community Relations, the School of Law, the Department of Political Science, the Center for Policy Studies, our panelists, the 2014 Student Constitution Day Committee, and our advisors, Dean Enton and Professors Tartikoff, White, and Lucker. At this time, you are all invited to proceed upstairs to the Black Acre Lounge, where refreshments will be served, and Professor Pfiffner will join us to answer any questions that remain. Thank you.